The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. Good morning. It's my understanding we have a couple schools represented here today. One of them is Audubon. Raise your hand if you're with the Audubon system. No? How about Dallas Center Grimes? There we go. Welcome. And I know my colleagues probably roll their eyes when I do this, but I think it's important for you to know we all have some high school that we call home. I graduated from Harlan High School, and I'll just go from my right to my left, back and forth, and I'll let the justices tell you what schools they graduated from.
I went to Bettendorf High School, class of 77.
Right to left.
And Dubuque Senior High, 1968.
I'm an Iowan by choice, so I went to Lexington High School in Lexington, Massachusetts.
Des Moines Lincoln High School, class of 92.
I graduated from Greenfield High School in 1986. That's now Nottoway Valley.
And I went to Kemper Catholic in Carroll, class of 1996.
Didn't mention my class of 80, same day Mount St. Helens erupted. Thank you, everyone, for being here. And I'm sure everyone else has a high school they'd like to brag about. We'll do that another day. We are here today for the submission of 4 separate cases. The case of Mary Deng versus Farmland Foods is hereby submitted without oral argument. The case of ACC Holdings versus Todd Rooney is also submitted without oral argument. And we're going to start our oral arguments today in the case of Amaya versus State Public Defender. And it is my understanding that Mr. Bushell is going to go first. Is that correct? And then I believe Mr. Ranscht is going to do rebuttal. Is that correct? Correct. Okay, thank you.
Also some of the argument, but
okay, I'll let you guys share your time.
Good morning. May it please, are we ready to start? Good morning. May it please the court, counsel. My name is Bill Bushell, and I'm here on behalf of the State Public Defender's Office. I want to start with some statistics or data. Since going into effect, over 75% of applicants have qualified under the statute. In fiscal year 2018, the State Public Defender paid about $180,000 in misodyne type claims. In fiscal year 21, that number was $82,000. And in fiscal year 22, to date, we're only partway through the year, but it's about $30,000. So the rule, indigent clients who are represented by retained counsel are entitled to ancillary services if the court finds that the requested service is reasonable and necessary, and that the client is unable to afford the necessary or requested service.
Particular case, if you had retained counsel at $60 an hour, wouldn't the cost to the state have been more than it was under the circumstances here where a third party paid the $15,000 retainer?
It could have been, certainly in this case. $1 an hour if we were to pay a contract attorney for all those attorney's fees, plus the ancillary expenses.
Money in a case where you already saved a lot of money.
In this particular case, it would have been probably less. So even in our own rules of criminal procedure, 2.204, witnesses for indigents, upon a finding, after appropriate inquiry, that the services are necessary and that the defendant is financially unable to provide the compensation, the court shall authorize counsel to obtain the witness on behalf of defendants. That's expert witnesses. That's in our Iowa Rules of Criminal Procedure. And there are almost identical provisions in other authorities.
Sorry to interrupt you, but I want to go back. I've just been thinking about your answers to my question, but it sounds like, and I want to give you an opportunity to correct this, So you save some money in terms of auxiliary expenses. You were citing some statistics, like 180,000 or thereabouts. But you also incur more expenses in terms of hourly rate if you have an hourly rate lawyer as compared to somebody who's privately retained. So the total cost picture isn't quite fairly represented by the 180,000. I mean, I want to give you an opportunity to push back and say, that's not quite right. Yeah, sure.
Cases go to a contract attorney where they're gonna bill our office at the hourly rate. It's $66 per hour now. So not all those cases are gonna go to contract attorneys. Almost all those cases are gonna go to our local public defender's office. It's only when they can't handle the case that it would go to a contract attorney and we would get a bill at that hourly rate. So most of the cases would be absorbed by the public defender system. Those are salaried employees, you know, that the costs are absorbed in those fixed costs of the salaried employees. So almost identical provisions in other authorities. For example, the ABA standard, 5-1.4 is the ABA standards for criminal justice. In the Federal Crime Act, or the Crime Act, 18 U.S.C. 3006 A.E.1, and the Federal Public Defenders, the CJA guidelines, Chapter 3, Section 310.1010, all have almost identical provisions.
What is the current CJA reimbursement for a contract attorney per hour?
Rate, I believe it's 158, the last time I looked, for
The State Public Defender's Office doing to get the reimbursement rate for contract attorneys in the state system, at least in the same ballpark as the federal rate?
It's a constant battle. We advocate, the legislature sets the hourly rate for contract attorneys in Iowa Code Section 815.7. So for us to advocate for raises is about all we can do. There's a lot of secondary material, a lot of meetings, a lot of handshaking, but really it's up to the legislature what the hourly rate is. The state public defender has no control over that. I think it is noteworthy that in the last 3 years, there have been 2 increases, totaling $6 per hour across the case types. So we do what we... The different case types, I think it's 66, 71, and 76. So an A felony, the top rate would be $76 per hour.
State or federal?
So all these authorities,
Impediment to getting contract lawyers, the fact that you don't pay travel time?
that's been discussed often.
A public defender lobbied for legislation that would allow contract lawyers to be reimbursed for their travel time?
Justice, I'm not the legislative liaison. I'm not sure what efforts have gone towards that.
Contract with a third-party payer matter at all?
I think that I would say that as a general rule, the contract between the client and the attorney does not bind the state.
With the client, though, right? So you have a fee agreement with the third-party payer on behalf of the client, and if the third-party payer says, this retainer is for attorney's fees only and not for auxiliary services, then what's the basis? And that may not be the facts of this case. Actually, I think it's not. But if it were the case, what would be the basis then for applying the statute when the contract specifically disallows the application of fees in that manner?
And I don't think the state can be bound to pay money based on the contract of some other parties, because that's what it would go to indigents or the client's ability to pay.
Access to those funds per the terms of the funding agreement.
Funds are earmarked and paid by that third party, they become available for the litigation. And
Why do you say that? Are you saying the third-party payer can't allocate funds in a fee agreement?
it would be prudent to separate out funds and representation in that way. Certainly, because that those parties entered into that agreement, it might go to indigence or ability to pay, but it would not bound the state public defender. And if that were allowed, it would invite complex and even finagled fee agreements and hourly rates. I see that I want to answer all the questions, but I really am running out of time, and I really want to kind of pass the ball over to Mr. Ranscht from the AG's office, if I could.
More question of you. It seems rather simplistic to me, but isn't it kind of like if somebody qualifies, the state will provide an appetizer, a main dish, and a dessert. And if somebody says, you know what, all I want is the dessert. Isn't that kind of what's going on here? They just want a portion of what the state would. It's still, like Justice Apple was saying, the state is still benefiting from not providing the appetizer and main dish. In other words, the legal services. Isn't that a fair assumption to say that it's still a savings for the state?
Not only if all cases went to contract attorneys, but because
Stand for something like that. I mean, we need to think about the different permutations, the effect this case is going to have. I'm giving you an example that's pretty common where whether it's a state public defender saying we're overwhelmed, we need to have somebody become state public appointed by his contract, or if somebody just chooses on their own with grandma and grandpa's money to hire someone. Regardless, that's got to save some skin off the state's budget.
it wouldn't appear so based on my experience in budgets and in the claims process. But I would say that that is a choice. That is a choice that the client has made. If someone is charged with a crime and they decide to hire private counsel, they can pay $50.
Not hiring. I guess I want to make sure we're on the same page. They're not hiring. Somebody's doing it for them.
The law could or should make that distinction. It's money paid either to or by or on behalf of the client.
It already make that distinction? When you're determining indigency, you look at funds or assets subject to execution to make that determination. So once that threshold determination's been made and the funds are provided by a third party, they're not the client funds. So why would you consider them when assessing the client's need for services?
Say that indigence, where you're, that bottom part of that financial affidavit that talks about assets subject to execution, I don't think we should mix up indigence and the inquiry that the court is to make on whether the client can afford the requested service. Indigence is a set standard. It's income and assets against the federal poverty guidelines. Ability to pay for the requested service is directly related to the retainer paid. And the statute doesn't make a distinction of who pays it or how it's tagged. Once it goes to the benefit of the client in this litigation, it can be used for attorney's fees.
Bringing grandma back into the situation, it seems like you're trying to require her then to pony up some more money because you're considering her contribution. And I'm making grandma up. I don't know who it was that contributed.
No, I would say that what the statute wants is they want the total cost of the litigation to be contemplated up front, not after the fact. Not grandma pays $5,000 for attorney's fees, and then 6 months later, oh, we're going to do depositions. Now grandma has to reach in her wallet and grab some more money. I don't think that's what the statute intends. The statute intends that if the client chooses to retain private counsel, that they contemplate all those costs up front. They say, okay, we got a criminal case, we're gonna need $10,000 in attorney's fees, we're gonna need $5,000 for depositions and an investigator, we're gonna need $2,500 for an expert. The statute wants those choices to be made with all the information available.
You don't know until you get into it what the total cost is going to be. So what if they had here said, instead of $15,000, $4,000, and then grandma says, come back and see me later, and I'll see if I can do more then? I mean, what happens?
Contemplates that because part of the calculation is hours required in the case, or hours in the case to date, and anticipated hours to finish the case. I mean, as attorneys, as litigators, we know that it's a dynamic landscape. But at some point, you have to be able to predict, even if you guess long, you're gonna, all those hours are gonna eat up that retainer. And in that case, that person's going to qualify under the statute, probably.
About court-appointed and privately retained, and also sometimes private lawyers who have been asked by State Public Defender's Office to jump in as court-appointed for the moment for that case. I have great faith, immense faith in the work of the Public Defender's Office. I do. I've seen it up close and personal myself, and I think sometimes there might be a mistaken belief that they need to hire private, when actually it's the PD's office who's in and out every day and is very familiar with the players, the court system. So anyway, I have great faith, but I also firmly believe in the right to choose, even if I might think someone didn't make the best choice. Aren't you requiring a client to, in a sense, make a choice between either you get to pick who you want or you get the services you need, but you can't have both?
I don't think that the statute makes that distinction or forces that choice.
But doesn't it have that effect?
Cases, but the client is choosing to hire private counsel. With that choice becomes all this information and all these outcomes or consequences of that choice.
To hire private counsel, the penalty is you don't have access to auxiliary funds.
Call it a penalty, but I would say that choices have consequences, and if you want to have a private attorney, you need to be able to pay for that litigation. If I couldn't afford, I'm not supposed to use me as an example, if a person couldn't afford to hire a private attorney for whatever the litigation is, then they can't afford that attorney. If it's the state's obligation in a criminal case for an indigent charged with a crime that the state provide them with an attorney. We have not come anywhere close to that constitutional floor. The statute, the choices made.
In the group of jurisdictions that see those rights as a bundle, that either if you want the ancillary services, then you have to take the state paid for attorney as well?
No, Justice, I think that the statute does a great balance act. It doesn't deny services to people with retained counsel. 75% of them qualify. All it does is it attempts to be good stewards of the public money, and it kind of draws a line that says that if the money paid on your behalf is sufficient to cover the cost of the ancillary services, you probably should pay for those on your own. But in cases where you can't afford the ancillary service, the state will come in and cover those services for you. You still get your right to choose choice of counsel if you want to hire private counsel. I don't want to get that confused with the right to choose which public defender you get, because that there's no right there. If I've ever said that there's no constitutional right to choice of counsel, what I mean is there's no right to choice of which public defender you get. You definitely have the constitutional right to choose to hire a private attorney or to have no attorney at all. That's solid. But I want to reiterate that the statute and 815 together does not come anywhere close to that constitutional floor. And if that constitutional floor is that when an indigent is charged with a crime in the state of Iowa and they can't afford an attorney or services, those attorneys and services will be provided for them. We're nowhere near that constitutional floor. This statute pays 75% of the applicants that apply under the statute qualify. We're paying for those services for indigents with retained counsel. But if you get a big retainer and there's a big pot of money sitting there, the statute and the taxpayers of the state of Iowa probably expect you to pay for your own ancillary services.
Hogging your time, when you said, I'd like to hand it over, and we kind of didn't let you. So would you please put 5 more minutes on the clock? I feel like we completely took time away, and I see him sitting there wondering, do I not get to say a word? So if you want to wrap up, like 10 words.
Just to wrap up, once again, we're nowhere near that constitutional floor. An indigent charged with a crime in the state of Iowa who can't afford an attorney or ancillary services, the statute doesn't take anything away from that. 75% of applicants apply. It's a good statute, and we would ask that you uphold the constitutionality of 815-1.
Thank you, Madam Chief Justice. Appreciate the indulgence and in the courts allowing me to argue on behalf of an amicus today. Justice McDonald, you asked, does the language of the contract matter? It does. The language of the contract in this case contemplates private payment of expenses, including depositions and investigators. The contract calls a $15,000 an initial deposit, and it requires an agreement to deposit more upon request at any time, plus an agreement that deposit is an estimate of total fees. That's the language of the contract. And unlike, for example, in the California case, Tran, I think that may be what you were referencing in saying, what if the agreement says we're limiting this retainer only to attorney fees and not expenses? That clause was in the contract in the California case. The agreement said this is only for attorney fees, and we're going to seek funding from the court for public funding to go forward with the case. So those were factors in the court's decision in California. The language of the contract here similarly matters.
Position or the state's position then that if this contract were different and it excluded the payment of auxiliary services from this retainer, then it's a different case and the services should be allowed?
Be different to think about, certainly, if the contract were closer to that California example with the express language. But
If we make this case turn on the wording of the contract, you're just going to see private counsel wording their contracts along the lines of the decision that we write, and then the legislature is going to pass another law. So, yeah, what is the state's position here? Maybe think about it a little bit.
Insurance law develops, isn't it? Insurance companies keep rewriting policies, and then decisions get made on the language of those policies. Really, though, the position here is that there's something that's been overlooked in the record, and that is there was no finding whatsoever of reasonableness or necessity. Even under the English case, those are requirements.
I mean, is it the state's position that English is no longer good law? Because English relied on the Sixth Amendment. A few years after that, in the Aki case, I think it is, the U.S. Supreme Court said that ancillary services are not governed by the Sixth Amendment. It's just the general due process right to a defense. So is English no longer good law?
You need to seriously consider is
Position. Is it or isn't it?
if you have to confront English at all, then yes, Aki superseded it with respect to the right to ancillary or auxiliary services. Aki puts those in the due process category and not in the effective assistance category.
Process category, then really the issue is the defendant being afforded an appropriate defense under the state scheme as opposed to are there right to counsel being affected, right?
Really, there are multiple paths that this case could take. All of them, I think, lead to a remand of some sort. One of them is that there was no finding of reasonableness or necessity. The motion asked for a blank check, any investigative or deposition expenses. There was no identification of who the investigator would be, how many
Did not challenge that. They assumed reasonableness and necessity for purposes of the motion. Isn't that correct?
Right. In the transcript below, in the hearing on this matter, public defender came in and said they took no position because it was the court's obligation to be satisfied that these were reasonable and necessary. This wasn't the public defender giving a green light and saying, we agree these are reasonable and necessary, just that the burden falls instead upon the applicant and then the court to be satisfied that they are reasonable and necessary. That's directly out of a 1973 case, State versus Williams.
A deficiency in the record here that isn't required in any other situation. I'm imagining when requests are made, not with a private retainer, but just wanting to have extra, like another evaluation, or we want this kind of work. When it gets to a point where it's more than normal, I don't recall there being all of those details provided on other cases, just in general.
The theme of the case law after English. Coker is an example, Aguilar is an example. Those are cases that discuss whether a litigant adequately showed reasonableness and necessity. So there is a strand in the case law about it.
Did the Public Defender's Office attempt to make a record on, or request a record? Did they ask for anything more?
Nobody did. The applicant didn't make a record, didn't identify a proposed investigator, didn't identify what that investigator's rate was, I understand that that also can get into revealing the defense, but we have the Dahl line of cases that deal with that. That simply wasn't done here. I see my time has expired. Again, thank you for the indulgence and the extra time. See you on rebuttal.
Is that correct? You'll be arguing? Okay.
May it please the court, counsel. 40 years ago, Mark English hired my law partner, Alfredo Parrish, to represent him on a theft case. He went to District Court Judge Misseldine and asked him, by Alfredo's recollection, for $85 for a handwriting expert. Judge Misseldine said that he didn't think that was appropriate. Alfredo came in front of you all, not you in particular, but this court, and 40 years ago you said that he was right, that indigent people still get auxiliary services.
Well, it is clear, at least under federal law, that the United States Supreme Court has moved away from one of the building blocks, I think, of the Misseldine case, and maybe converted it into due process. Where does that land you?
You know, I'm not the best Appellee's attorney. I usually sit at the other table, but we did preserve the issue of raising this under due process, but the district court didn't take it up. I would say that the argument does not change significantly under the due process, and it is basically academic. In this case, the real heart of this issue are two things. One, the statute here doesn't do what it says it's supposed to do. We have made a record through our arguments all along that this statute doesn't save money. And we have begged to hear from the opposing parties, does the...
Follow up on a question from Justice McDonald earlier. If we're going to talk about the statute, before you even get to the rate by the contract attorney, it talks about the monies paid or to be paid to the privately retained attorney. And your fee agreement with Mr. Amaya's mother requires her to, she agreed to cover the very expenses that are at issue here. And so why do we even need to get beyond that?
That's true, Your Honor, but I would say that in this case, the state still owes a duty to offer those expenses because, as the court found, that retainer is going to get eaten up with fees.
She's not obligated, she's obligated beyond the retainer, though, isn't she? Under the agreement says she'll pay $15,000 plus she'll pay, either reimburse you or pay herself for these fees.
Not exactly, Your Honor. I don't think that is, well, I can tell you this, that is not how we treat the agreement. We treat the agreement as, this is...
Because that's exactly what it says.
during the initial argument, and that's going to get done here probably by the end of the week. And I understand that, but the fact of the matter is it goes to a more central issue of the case, is that when I have Mexican immigrant Mrs. Amaya, the mom, come up and call everybody for $15,000, I definitely don't have a factual expectation that I'm going to get any more money out of the case.
Establish that no more money was available from the third party? You have a contractual right to it, it sounds like. I mean, correct me if I'm wrong, as always, but you could look at you could take your contract and say, well, we're going to exhaust the 15 grand, we need 5 grand more, you've agreed to it, pay up. And has that been done, and has she said, nope, out of dough?
So two things. I don't think the record reflects it, but the fact of the matter is there is no more money. That's a great point. And I'm not sure the record does reflect that, but that's where we're at. And I would also, though I wanted to talk about this a little later, I think this issue needs to be handled head-on, and I ask you all to handle it head-on. I take Justice Mansfield's point that why have 5 arguments about this before we get to the real issue here? This needs to be handled now because it involves Iowans, and it involves poor Iowans, and it involves the nearly poor Iowans. And I think that we sometimes think of this as sort of the switch gets flipped, like this light switches, that you're poor, but then all of a sudden you're not poor. And this case doesn't affect just the poor defendant. We have to consider that it also affects the poor third parties that gather the money to get an attorney so that they can exercise their choice of counsel.
It seems to me that what this statute somewhat does is the legislature says, on a case like this, we're going to pay X, and here it's something like $6,000, right? And that's based on a $63 per hour fee. And based on the contract for $15,000 applies a $300 per hour fee. Isn't somewhat the question for this court, what is that reasonable fee that we can rely on? And isn't it the legislature's job to sort of set what that fee is? I mean, is it our job to come in and say, the legislature's wrong, that $63 is sort of the proper multiplier here, and that we should apply some other number, $300 or $400 or, you know, whatever the kind of separate fee is?
Yes, Your Honors. It's not how I was going to ask you to rule on the case at the end. I was going to ask you to simply confirm the district court's well-reasoned ruling. However, I think it would be an opportunity for this court to recognize that $63 or $66 an hour is a pittance. I filed an additional authority that IASB President Angie Schutz found, and I actually don't agree, I think it's low, that an attorney doesn't even make money until they make $75 an hour. And so I question that. I think that it needs to be higher than $75 an hour. So
About that, but in terms of this record, what do we have in this record to say that as a constitutional matter, that rate, you know, doesn't get high enough and we need to, you know?
I would say, what more would you need, Your Honor? Would you need an affidavit from, say, Leon Spies or Alfredo Parrish or the partners at Nine Master, Ballin, Davis, to say that that's a pittance and our offices would close if that's what we got paid? Because I think that we can also take judicial notice, and we all know things. We know that it's a pittance, and I don't know what more record you would need, Your Honor.
Statute, and I want to kind of address this fact question. It doesn't require you to work for that fee at $63 an hour. So if you, let's say the cost of the investigator and depositions here is $5,000 total, which would be high, I think, in my experience. So, but let's say it's $5,000. That still leaves $10,000 of the retainer for attorney's fees. And based on your projected hours from the district court, that's still a rate of $116 per hour. And I'm not going to argue that that's a good rate, but it's not 63, right?
If I get paid, you know, a couple blocks from here on the CJ panel either.
But it doesn't force you, and it doesn't result in the firm having to take $63 an hour. You know, more likely than not, a typical fee in this case for an investigator would be $1,500, $2,000.
To speak brass tacks, it's a child pornography case, and there was going to be an application for an expert as to the nature of that file and what it depicts as well. We hadn't got there yet. But what it will result in is that I'm not going to take the case, or that Al is not going to go to mental health hearings every other Friday, is it? Or one Friday a month, because our firm can't do both. It's going to result in that defendant is going to be at a risk of not getting that expert that he needs, because the fundamental problem here is that this is supposed to save money. But
Problem that 66 an hour is too low, like we've been talking about. I mean, I left the Bellin Law Firm, which you just referenced, in 1996, and $66 an hour was less than I had to pay, essentially as a partner, pay the firm to cover my overhead per hour. So it's, I understand where you're coming from, but that's a separate issue. What we have here is, under Aki, what seems like a due process right to a defense. And so the question I'm struggling with is, under this legislative scheme, I may not like it as a policy matter. I definitely don't like $66 an hour. I think it's outrageously low. But is this a scheme that deprives the client of a defense? And that I struggle with because you have many, many clients that get no private attorney at all.
And I say it does deprive a defendant of a defense. For instance, take this case, which I will concede is not in the record. But in this case, we have Mr. Amaya that speaks English, but his family that doesn't speak Spanish, and they want an attorney that spoke Spanish. I'm not sure, since Mr. Rodriguez left, there's one attorney in the state public defender system that speaks Spanish. How can Mr. Amaya be defended correctly if the people that have the knowledge about this person in order to engage in plea negotiations can't communicate with the state public defender?
Maybe I'll make interpreters available.
But I would say that, one, I hope that every Karen person in Des Moines, in the state of Iowa, gets an interpreter. But I hope you don't have to go through the process of getting that interpreter, because it is nigh impossible. I am almost in a position where I have a case that I litigated in federal court where I'm going to have to ask the federal government to reschedule an interview around the one Karen interpreter in Des Moines' availability. So there is a conflict there, Your Honor, between the due process right to counsel and also the choice of counsel, because someone still has a Sixth Amendment right to counsel, and that was conceded in oral argument. So this case was also raised under the Iowa Constitution and the Iowa Constitution's right to counsel. And Your Honors could just as easily as accept the Aki reasoning simply say that the Iowa Constitution offers this right to counsel, and that would even be easier.
By the way, I misspoke. It's 96. That's when I joined the Bellin firm, 2009. I'm sorry. So I went swimming this morning and my head is chlorinated. Sorry.
Going back to Justice McDermott's question, what would be the exact holding that you would request of this court? Is it that the rate, well, I'm not going to set that aside. Is it that the court should always make some sort of determination of a reasonable fee on a case-by-case basis? Is it that the statute in its entirety is unconstitutional, and once an indigency finding has been made under English, no further inquiry is necessary? What would you have us do?
Simply uphold the district court's ruling, and if you're concerned about the ACA issue, simply make the small change that you also find it under the Iowa Constitution. And there you have really safe harbor on this, because since Missildine, you also have the reasonable ability to pay analysis. And at the conclusion of the case, the state public defender can engage with the defendant to determine if the defendant has a reasonable ability to pay. And I think up until cross-examination, that would meet the best of all worlds and allow individuals to continue to engage in their Sixth Amendment and Iowa constitutional right to counsel. That's what I would like.
So the district court just severed the statute and said it was only the part that required to use the $63 or $66, whatever it is. If we were to affirm that, what does that do for anyone who had the services of a contract attorney who was paid $63 an hour? Does that open up some kind of, if this is based on effective assistance of counsel, does that somehow say that $63 an hour is in itself unconstitutional as providing ineffective assistance?
I would love for you to say that, but I'm not sure that's before you.
It's not, but that's my question. Is that the next case? Is that in effect what the district court was saying? Is that by paying an attorney, limiting an attorney to that rate, if that in itself is unconstitutional, what does that do for people who had attorneys at that rate?
To answer your question head on, I think the district court was talking about the Hobson's choice that one has between exercising one's right to counsel versus getting the auxiliary services. I don't think the opinion of this court will reach that far, but it would be lovely if you did.
Is there a need to remand? Are there gaps in the record that need to be filled before we make a record, our decision on reasonableness or necessity of the expert, or you're shaking your head no?
I think that, I don't know by exact count, but many of you sat on a district court, or at least, were in court to ask for depositions, and an investigator in a Class C felony sex case is a foregone conclusion.
Be here today if things happened differently. Let's say that Mr. Amaya applied for and was provided an attorney through the State Public Defender's Office, And let's assume that that attorney asked for all the same extras that you guys are asking for now. And let's assume they were all covered. And after all of those incidentals and extras were provided for, then grandma hires a lawyer for him.
Well, you stole the example that I had written down, so I'm not sure how that would have affected this case, but it clearly shows the juxtaposition of what the problem is. And I don't know what the answer is then. So if this statute is constitutional, then does that mean that because I got the services, say, through my friend Trevor at the Public Defender's Office with the Special Defender, so then because I'm using them, then do I have to lower my rate to $66 an hour? I'm not sure what that means, and I'm not sure how the State Public Defender is going to handle that. I think it actually highlights another problem. Does the State Public Defender get to go into my trust account if they paid a reasonable necessary service, but then I use it?
Uhlenhop's special concurrence where he talked about, no, it's nobody's business until you ask for public assistance.
And in this case, I did give the district court my fee agreement. I did have it under seal, but you've got it. You've talked about it, and I'm not that ashamed of it. My time is up, I think. I just want you all to remember that this is easy.
Is the fact that $66 is too low, is that an adjudicative fact that we would need, to develop an evidentiary record of, or is that a legislative fact that based on our common experience we could pronounce?
The latter. And on that, Justice Waterman, I want to note that your comments last Friday were timely, that the Supreme Court in the Missildine case, they were no dummies. They knew that this didn't save money at all. They had a well-reasoned opinion, and Judge Crane also had a well-reasoned opinion. It's pretty low-hanging fruit. You can tell that we agree. You can say we agree with Judge Crane's reasoning, but we also amend our holding in Missildine that it is also under the Iowa Constitution. And I also encourage you to remember that you are also stewards of the justice system here in the state of Iowa. And it is important to allow defendants, the poor and the near poor, they gather all their money together to defend their loved one, which could be any of our loved ones here. It could be that when we gather the money together to hire an attorney to represent our loved ones, that is something that we should support in this justice system, and I ask you to do that. Thank you, Your Honors.
I believe it's Mr. Ranscht who's going to go again?
That's correct.
Thank you.
I heard a lot of, this isn't in the record, but. That's not how appeals work. That's not how cases are resolved. Justice McDermott, you asked, what about the record? What should be in the record? For that, all you need to do is look at Parrish versus Donato from 1978, where Parrish came all the way up to this court after being prevented from introducing evidence or affidavits about what was a reasonable rate and what was a reasonable service. That's what's not in the record here. Justice Oxley, in terms of $63 being automatically ineffective, that crystallizes and highlights the problem with this being tethered to the right to counsel rather than the due process issue.
Due process, if it is under due process, Aki talked a lot about compelling interests and substantial burdens. Why is it not strict scrutiny rather than rational basis?
It's not strict scrutiny because the right to choice of counsel doesn't extend under Kaplan and Drysdale to the right to spend someone else's money, whether that is the state's money, whether that's your family's money.
When you read Aki, do you read it as applying a rational basis? Because I read it more as applying a strict scrutiny.
I think Aki is close to that. The other thing that it does, though, is in setting the due process right, it expressly puts limits on it. So, for example, you have to have access to the raw materials, but you have no constitutional right to choose the provider, right? You also have no constitutional rights to receive funds to hire one that you select. So the personal selection there is a big component of what Aki provides.
But so in, I don't think that part The statute is being challenged, but if Mr. Amaya came in and said, I would like the state to hire the investigator, the state can pick the investigator, but I just want them to pay for it, would that be, I mean, does that make a difference?
I think that would be permissible under Aki. I think that is consistent with some other states that have addressed this, where
I think in Aki, it was, the specific facts were that they, wanted to hire the psychiatrist of their choice. And so that's a little bit different issue, I think, than what's at issue here, because the statute's set up to say, we're not going to require the state to be the one to hire the investigator as long as it's reasonable and necessary. And putting aside whether or not it was conceded or whether or not the record shows that the investigator expenses were reasonable and necessary, assuming that they were, that they got a really good deal on an investigator. I don't see that it's not so much a matter of the choice or the investigator the choice, it's just a matter of who's going to pay for it.
Sure, I follow.
Is a distinction, at least in my mind, from Aki, where it was, when you talk about, well, you're not entitled to an investigator of your choice, true, but that's not what they're asking for. They're just asking for payment for the investigator, which under due process, I think Aki says, should be provided, at least in certain circumstances.
That Aki also says that states can implement the right in differing ways. You have seen and you have referenced that there are at least 4 or 5 other states that implement this with a kind of a package deal. So that is a option. If that's what you conclude Section 815.1 does, then you can look at those other states. It's Maryland, Colorado, Utah, and Delaware.
In conflict with English, our English case, so.
Why I've focused sort of on the evidentiary showing. That's a way that you don't need to, constitutional avoidance, right? Constitutional avoidance is important. That's a way that you can resolve this case without having to get to English.
We'll just be in the soup with another case immediately. Does the state agree that the Iowa Constitution was raised below in addition to the Sixth Amendment? And
Iowa Constitution was raised below. There was no development of a reason why the Iowa Constitution would provide a different standard other than the Iowa Constitution has, with other clauses, sometimes provided a different standard, as the Iowa Supreme Court has ruled. So it was raised minimally, developed, I'm not sure. And importantly, English itself also never raised the Iowa Constitution. They considered statute, rule of criminal procedure, and of course the Sixth Amendment. Sure.
Before it turns red. The hypothetical that I gave opposing counsel, if the event had occurred in opposite chronology, would the state be requesting reimbursement?
Would the state be requesting reimbursement? Under 815, I think it's .9, they have the ability to do so, but that's from the defendant, not from the lawyer. So the defendant's reimbursement under 815 would be subject to reasonable ability to pay. Notably, too, the public defender did appear in this case. Amaya came to the court, applied for a public defender, got one. The only reason the public defender came off this case was the retention of private counsel. I see my time has expired. Thank you again.
Versus State Public Defender is hereby submitted. And we'll have a quick transition of attorneys before we get ready for Garrison versus New Fashion Pork.